We welcome you back to another edition of Chicago's Legal Latte. Hi, everyone. I'm Jim Mitchell. And on this edition of the podcast, I welcome once again attorney Tim Hughes of Lavelle Law. Tim is here to talk to us about interesting topic in the news, one that is going to get some attention. And this conversation is going to take a look from a little bit different angle. So first of all, Tim, always a pleasure to have you here. Thanks for joining me today.
Oh, thanks for having me, Jim. Always a pleasure.
So I mentioned kind of a topical subject today. We're going to talk about student loan forgiveness, but interesting as we are recording this conversation, the Supreme Court is hearing arguments about the president's desire to forgive student loan, but it's not really our focus today. Ours is more dealing with a Department of Justice initiative and some lawsuits that have been brought because it deals specifically with bankruptcy. So we're going to talk about discharging student debt through bankruptcy. And just quickly, is this kind of a new topic, or is this something that you've dealt with in the past?
It's not a new topic per se. People always think that student loans are not dischargeable in bankruptcy, and that's not actually the case. There's a presumption that they're not dischargeable, but the debtor, the borrower, has a very, very difficult road to or hurdles to overcome in overcoming that presumption. It used to be that they had to establish essentially a certainty of hopelessness in their life, and that got refined or lowered a little bit from a certainty of hopelessness to what's a Bruner test, which was still very difficult. It was the present ability to pay, future ability to pay, and what was the debtor's good faith efforts between the time of the loan and the filing of the bankruptcy. And it's that three-part test that back in November of 2022, the DOJ said we need a little more uniformity and maybe not have such a draconian view on the those three-part tests. So they won't say they lowered the standard, but they got it more uniform with this administration's policies. So it's applicable for cases that are open as of November 17, 2022 and thereafter.
Well, a couple of things we're going to dive into there, and having had you on the podcast many times in the past, we know there's different types of bankruptcy, and we'll talk about if this applies to all. But I think what gets lost in many of these conversations is there's also a lot of different types of student loans that can create debt. Do you have, or can you share just some of the different types? Because I know there's grants, there's loans, there's private loans. Are they all covered in this?
No, the dischargeability is for government loans issued by the government, not backed by the government, but issued by the government. So if you went through a private lender, they may get backing from the government, but that being a private student loan is not covered by this. This initiative only covers the actual loans from the government directly, but it still covers a large number, but not the vast majority of cases.
And you mentioned the November 22 introduction of the three-part test. Is there a time frame on when these loans originated? Does it go back to any existing loan, or do we know what the coverage might be?
Any existing loan is covered, again, issued by the federal government, and it's only able to be asserted by a debtor that has their case open. So if somebody received a discharge and their case was closed the day before the initiative, they cannot reopen their case to file this adversary. An adversary is a lawsuit in the bankruptcy to resolve a specific item, and in this case, the dischargeability of a student loan.
Now, have you handled cases like this? Have you had filings, and is any experience going through this new process?
In 30 years, we've only had, one before this DOJ announcement. And that didn't come to a conclusion because of various reasons. We just recently filed one now on a case that we believe fits the criteria outlined by the DOJ. So I'm hoping to meet with you again on favorable results.
Excellent. So let's go into some of the details. You had mentioned the new three-part test. Can you kind of take us through what those steps are now and what it means for you or your client, that what steps they'll need to go through?
Okay. The first is almost a gimme. It's present inability to pay. And typically, if somebody's in a bankruptcy, they're having difficulty paying their debts as they come due. So that is looked at or is one of the criteria. And again, it may take a little more heightened view by DOJ and saying, you know, whether a certain expense is legit or this or that. But that first prong should be somewhat easily made. The second is future ability to pay. Now, future ability to pay just assumes that that present is not just a photo of today, but it's of the future. And the future is a long, long time ahead. That some of the factors that they'll look at for inability to pay are the loans well over 10 years? Is the person filing over the age of 65? Inability to pay, you know, in the past 10 years, were they unemployed for 5 years or more? Are they disabled? And some other factors like that. So the future ability to pay really takes some work and unique circumstances to show that that's going to be that going forward. Good faith efforts are what happened prior to the filing of the bankruptcy. Did this person, you know, get the student loans? And another factor on the or good faith is also did they graduate? You know, did something happen to prevent them from graduating? You know, if they were going to medical school and they got into a car accident and could no longer be a surgeon, but then change careers or this or that, then that's a factor. Or did they make some payments? And going to the lender and saying, I can't pay, is good faith effort. If they deemed you in a deferment because you had the inability to pay, that's good faith, that you communicated and contacted them and said, at this time, I can't pay. So that's not going to be held against you. It's not that you have to have X number of payments per year to show good faith.
So presenting the findings or the claims in these three areas now, does that go to the court? Does that go to the DOJ? Who handles that analysis in the process?
Well, in the lawsuit, the judge is the final arbitrator of the decision, but to help the judge, the DOJ developed a debtor attestation form that is rather involved, and DOJ will work with the plaintiff or the debtor in evaluating that, and then it may be a decision of between the parties that this is a fair amount, or if they can't agree, then it goes to the judge who will then make a decision.
We're talking with shareholder Timothy Hughes of Lavelle Law today, taking a look at the question of whether or not student loan debts can be forgiven in a bankruptcy filing. Talking about a new process that was instituted in November of 2022 by the DOJ, and we're kind of getting an update on that. You mentioned, Tim, at the beginning that there was a significant threshold in the past that made it virtually impossible to pursue this. Now you've outlined, some steps that may require some legwork and some effort to prove a point. From your view as an attorney handling bankruptcy cases, is this a viable opportunity? Does this look like it's at least gives opportunity to some of these people as opposed to what they faced in the past?
Yes, it does seem to kind of give a more favorable possibility for a reduction in student loan debt, again, issued by the federal government, for those cases where there is a hardship and it, doesn't, or it looks permanent, and that relief should be granted. In the past, there was that three-part test that how the courts were viewing that was very difficult to overcome. But at least from what we're seeing right now, the government is going to be more, I won't say giving away the store, but will be a little more relaxed in applying the standards.
Is this going to be a binary decision? It's all forgiven or not forgiven, or would there be some negotiation or some amount?
It's in the legal field, so it's always that gray area. A resolution could be, you have 100,000 student loan. We think your hardship warrants relief of 70,000, that you could pay 30. And if the debtor doesn't believe that, then they can go to the judge, and the judge could say, hey, I think you can pay half of it. Or the judge could say, you can't pay any of it.
Got it. And for the various factors that the DOJ will look at, are they all kind of weighed the same, or are there certain pieces that they go, well, that's the first thing we're going to look at, and that's the key one?
They haven't provided a weighting system for the factors, and it's our job to say that the factors in favor of the client are the most heavily, or should be the most heavily weighted. So it all depends.
Now, as you look at a normal bankruptcy proceeding, I know sometimes they can take some time to wind their way through, and this being a sort of a new instance, do you anticipate that these cases are going to take a little bit longer? What's your outlook in terms of how courts might start dealing with this kind of new initiative?
Okay, well, that answers one of your questions that you didn't directly ask me earlier. Does it apply to Chapter 7 and 13 and
that was
11?
coming. Okay.
And the short answer is yes, it applies to all three.
Okay.
An 11 and a 13 can go 5 years. So, and I guess as long as the case is open, that adversary could be filed towards the end of the proceeding. It would probably make more sense to file it sooner than later. But there may be a few reasons why you'd wait longer down the road. In the Chapter 7, that proceeding is relatively quick. From start to finish, it's a little over maybe 90 days. It can be extended, but the debtor in a Chapter 7 has to make a quick decision and get the adversary filed while the case is open.
Okay. This is all new, as you mentioned, a lot of recent changes and things that we'll be going through for the first time. Anything else about this process that someone who's in this situation might want to be aware of, if it's kind of on their radar? Any other things we didn't cover today that should be discussed?
Well, they should kind of look at their student loan history and kind of see what progress they made towards resolving it, what steps they took, or if they didn't, why didn't they? And if they come to their bankruptcy attorney, they should be able to say, hey, I've got the student loan directly from the federal government, and explain why they think it's not fair to repay it.
Okay. Always a lot of good information available at lavellelaw.com, including information about views. But for people who want to maybe have a detailed conversation about this topic, Tim, best way to reach you to have that conversation?
Either can call at 847-705-7555 and ask for me, or email thughes@lavellelaw.com, or go to our website and contact me via that. That's www.lavellelaw.com.
Wonderful. Tim Hughes, thanks for joining us. Great conversation today. And as you said, let's get together and talk again once that case gets resolved. We learn a little bit more about it.
Sounds good.
Thanks, Tim.
Bye.